Thank you for coming, everybody. I was at a mediation in Columbus all day yesterday, which was kind of a mess, but that's another story. And as I'm driving back, Bob emails me and says, well, our managing partner, Peter Turner, who usually does these introductions, isn't able to attend today. So do you want to do the introductions, or should I? And I thought about it and I said, you know, age before beauty, and I'm speaking first, so I'll let Bob take the honors. But I do thank everybody for coming out this morning. It looks like winter is finally here. I'm going to talk about Ohio's new receivership statute. When we originally thought about doing this presentation last summer, when the three of us first talked about this receivership statute was really new. But it's still pretty new. It's been in effect about 8 months. And there's a number of changes, and the most prominent changes to the receivership statute are to assist in the expeditious, orderly sale of real property free and clear of liens. The history of the law, which actually different real property groups and some bankruptcy lawyers and talked about doing these amendments back in 2012. And finally, what was House Bill 9 was signed into law by Governor Kasich on December 19th, 2014. And the new law became effective on March 23rd of 2015. And what the law does, it doesn't so much change Ohio law, but it provides some clarity and uniformity. A lot of what the statute entails was set forth in case law, but because case law can vary from county to county, there was still some hesitancy and some lack of confidence that this was a uniform law and procedures for selling property and the other things that this new statute tries to provide some certainty and clarity and uniformity. What the law primarily does, and there's some minor changes that we're really not going to get into here, but what the law primarily does is it modifies the way receivers can be appointed. It's actually easier to appoint a receiver in Ohio now than it used to be before this statute. And it adds to and clarifies the powers of receivers, including, most importantly, the power to sell real property free and clear of liens. The Ohio receivership statute is codified at Revised Code Section 2735, and I'm just going to go over some of the changes to various sections of that, and then we're going to focus mainly on the changes to 2735.04, which talks about the powers of receivers and also talks about the enhanced ability to sell real property free and clear of liens. 2735.01 is what prescribes when a receiver can be appointed. And if you look at the red here, that's the new language. It used to be, if you're talking about a borrower, a lender, a mortgagee, who wanted to appoint a receiver in the event of a default, you had to show default, and you also had to show that the property is probably insufficient to discharge the debt. If you look at some of the old case law or pre-statute case law, it talks about how receiverships are extraordinary circumstances, and it was more of a case of last resort instead of a case of first resort. That's not the case anymore. If you have in your loan documents the consent of the borrower to the appointment of a receiver in the event of default, that's ball game now. It used to be that even if you had that language in the document, the court would still go through to see if these extraordinary circumstances exist, but not anymore. If you have default and you have a writing which authorizes the lender to put a receiver in place, there's going to be a receiver. Another new provision of the statute is that a receiver may be appointed by a court if there is to enforce a contractual assignment of rents and leases. That's new. So for income-producing property, if there's a default on a mortgage and the lender wants to put a a third party in place to make sure that the income that's thrown off of that property goes down to pay the debt instead of it being put in the owner's pocket or going elsewhere. You could get a receiver appointed automatically in those circumstances. That did not used to be the case. There's some changes to 273502, which talks about who is appointed as receiver. Now, this first bullet point is interesting. It says, in selecting a receiver, priority consideration shall be afforded to any of the qualified persons nominated by the party seeking the receivership. The statute's so new, so I don't know what priority consideration means, whether if the lender wants a specific person to be a receiver or a specific entity, that receiver will be appointed, because it's just too new. I could tell you how it used to be. It used to be a coronation by whatever judge had the case of who contributed most heavily to his or her political campaign. There was a lot of patronage involved, and we'll have to see how this priority consideration plays out. But at least, and it does say no nomination is binding upon the court, but at least there is some language in the statute that says the court should give priority consideration to who the lender wants to nominate as the receiver. The only thing the statute says about who can't be a receiver is a party can't be a receiver, attorney for the party can't be a receiver unless the owner and all the parties with an interest in the property consent. Another thing, another limitation on the appointment of a receiver, that if you are appointed, or if there is an application to appoint a receiver of an entity, a corporation, a partnership, limited liability company, or any other entity that's created under Ohio law, the receiver has to be a resident of this state. So there's a little bit of patronage there. I was involved in a case where a lender, is actually a special servicer, wanted to appoint an out-of-state receiver for a well-known property that went into receivership in Northeast Ohio. The receiver was out of Chicago. The court did not appoint the receiver out of Chicago, appointed someone locally. And I was kind of bummed out about that because I think I had an in with the receiver in Chicago to be appointed as receiver's counsel. But you know, it does say that when the receivership is appointed for an entity, that the receiver has to be a resident of the state as well. Now we're going to get into the main changes that we're going to talk about, which is the sale of property free and clear of liens. The receivership, all of this red is new provisions to the statute, so all of these sections didn't exist before March 23rd of 2015. The new statute says that a receiver may sell property free and clear of liens by a variety of means. You could have a written purchase and sale agreement that you've actually negotiated and signed, and you could submit it to the court and say, we want to do this deal. I've been involved in those. I know some people that are here have been involved in those where there is a pending deal and we just want court approval of that, and rather than go through a foreclosure process to clear title, we just want the court to bless the transaction and transfer the liens on the property to the sale proceeds. It doesn't have to be a pre-negotiated written contract, though. You can have a private auction, and Mark's going to talk about private auctions. You could have a public auction similar to a foreclosure sale, but a more, not through the sheriff's office and not with some of the limitations and procedural mechanisms you have to go through what is an arduous foreclosure process. Or any other method that the court determines is fair and reasonable under the circumstances, so long as there's a belief that the return to the receivership estate is maximized. The new provisions also say that the court doesn't have to require a valuation, and if it does require a valuation, it doesn't have to be an MIA appraisal. When you go through the foreclosure process, there's usually 3 appraisers appointed, and it takes a long time. You also have that 2/3 minimum bid requirement in the foreclosure process. You could have a broker's opinion of value. You could have any valuation, and it says by any evidence that the court determines is appropriate. And it also says that in a public or private auction, and again, Mark will talk about those, you may establish a minimum bid. In foreclosures, it's mandated that it's a 2/3 minimum appraisal bid. You could have a higher minimum bid in a receivership auction, a lower minimum bid, or no minimum bid at all. So it's much more flexible. The last section on this slide talks about some of the things the courts can do when you do have a written contract. The court can say, well, I like that deal, but why don't you see if you could do better? And the court could say, go and see if there's some other deals out there in order to maximize the return to the receivership estate. If any of you have been involved in bankruptcy proceedings where there's what's called a stalking horse, that's what this is similar to, just to make sure that the property gets the best price possible. And it also says that if you do have a stalking horse situation, if there's an unsuccessful original purchaser that was involved to help generate maximum value, that original purchaser who didn't get the property can be paid his reasonable costs and expenses to the extent he contributed value to the receivership estate. Even though there's a lot of words in this statute, it's a pretty simple process for selling the property. You file an application. When I act as counsel for a receiver, we have a deal. We say, court, this is the deal we want to do. Here's the purchase agreement, or here's the auction procedure that we want to employ. Please bless this. Once that application to sell the property free and clear of liens is filed, you have to give at least 10 days prior notice, not a long period of time, to owners, parties, and all persons with a recorded or filed lien encumbering the property. Similar to who you would give notice to in a foreclosure proceeding of anybody who shows up on a preliminary judicial report. Then all of those interested parties have an opportunity to be heard. And if no one objects to the sale, the court can issue an order of sale without a hearing. If there is some objections, the court will hold a hearing and make a decision. Once that notice is provided, and if necessary, a hearing is held, the court issues an order that either blesses the required or the proposed procedure in the case of an auction, or blesses the proposed purchase and sale agreement that the receiver wishes to consummate. That's it. If the court blesses in the case of a written agreement, if the court issues that order of sale, that's the final appealable order. You don't have to wait for confirmation like you have to in a foreclosure sale. And really the property can proceed from that point on. What happens when that sale is consummated? The liens transfer to the sale proceeds in the receiver's hands in the same order of priority. I had a case in Scioto County where there was a huge lien dispute because there was some fraud involved where mortgages weren't recorded and refinancing proceeds were absconded. We had a huge fight over proceeds, and in a foreclosure, it would have lasted years. We had a receivership appointed. The property was sold at a much higher price than it would have had it gone to foreclosure. And although we still had the lien priority dispute, we fought over with the proceeds sitting in court and the property sold at maximized value. So once the court blesses that, it's now statutorily that those liens are off that property. What used to happen, I know there's some title insurance companies here that because this really wasn't statutorily mandated or prescribed and there was just some case law, that title insurance was hesitant to issue title insurance in a case where a receivership sale was issued free and clear of liens, especially when there was any objection, because it wasn't clear that this was a statutorily authorized process for clearing title to a property. It is now, and I believe that the title insurance problems that some people had with these types of transactions have, for the most part, fallen by the wayside. I see Bruce shaking his head, so I think that's an issue of the past, and that's one of the main benefits of this statute is that you don't have concerns over insurability of title given this statute that now says a receiver can sell property free and clear of liens. There is redemption rights like there is in foreclosure, but they're much shorter. They could be as little as 3 days. So where in a foreclosure sale where, first of all, you don't know what you're buying because you really don't have inspection or due diligence rights, and you're always worried that someone's going to come in and redeem, that it kind of chills the interest in the property and getting qualified and maximized purchase value. With this short redemption period, buyers or prospective purchasers in a receivership sale are going to feel more certain that they're going to get the property and they're going to get it more quickly without the time lags and the fear of redemption that exists in foreclosure proceedings. The new statute says that if you want to redeem, and again, this period could be as short as 3 days, the owner, in order to redeem, has to pay the greater of the purchase price or the value of all of the liens on the property, including all principal, interest, costs, and other amounts secured by the liens. Like I said about confirmation of sale, if it's a written contract, you don't need that confirmation any order anymore. Once the court approves the sale, the receiver just has to consummate the sale and basically execute and deliver a receiver's deed to the property and file a certificate and report of sale, basically said, I did what the court approved. If it's an auction or something where the sale order specifies a procedure as opposed to blesses a written contract, you still do have to get the confirmation, and then the court will say that, yes, the court-ordered auction process was followed and the sale was consummated in accordance with the procedures that the court approved. But for most cases where you actually have a deal in place, once that sale order goes on, there's no confirmation order needed, like there is in a foreclosure, actually in bankruptcy sales. So what are the benefits of all of these changes to the statute? Well, it's easier to get receivers appointed. Like I said, if you have a default and you have loan documents that say you can get a receiver appointed, it's done. For income-producing properties, you can get a receiver appointed where there's an assignment of leases and rents so that the income goes down to pay the loan. Again, there's deference to the applicant's receiver recommendation, and we'll have to see how that plays out, whether this priority consideration means the court actually appoints who the applicant wants, or he's just going to think about it, the court's going to think about it for a second, and then appoint whoever donates to his or her campaign the most. We'll have to see how that plays out. It allows for more orderly sales, which is going to maximize value because you could have inspections, you could have contingencies, you could have other due diligence activities as part of the sale process. You're not going to have the situation with the title insurance and the objections where it's going to be unclear as to whether a good title, free and clear of all liens, can actually be accomplished by this procedure because it is now statutorily prescribed. And again, with this shorter redemption period, there's going to be more likelihood that the purchaser in the receivership process gets the property and gets it more quickly. I know I went through a lot very quickly there. I hope it was understandable. If anyone has any questions now, we can take them. Otherwise, we'll just turn over the proceedings to Mark and go on. Yes?
So one of the things that is new that you mentioned was the court may require evidence of value. And that used to be a pillar upon which underwriting we would look at. And I think even though the court, it's may, I think it's a good practice for the pleadings and the motion and the order that you should state some value, and that the value of the property actually exceeds the debt, or less than the debt that you're foreclosing on. This is a safeguard for due process purposes.
I think it's a good point because, again, this whole receivership, a receiver has an obligation to maximize the value to the receivership. There is some judicial oversight and scrutiny here, so in order to make sure that all the i's are dotted and t's crossed, it's a good idea. And again, this says may. I think I would suspect that most courts would, in order to cover their you-know-what, would want to make sure that there's some evidence of value so they're not approving a sale that really isn't in the best interest of the estate. Yes?
If you sell a property, the receiver sells a property free and clear of all the liens, are the lien holders just out of luck?
No, what happens is, for example, the one I was involved in Scioto County, it was a $150,000 purchase price. The liens attached to the sale proceeds in the order of their priority. So if the first lien holder had a $100,000 mortgage actually the only lien that doesn't transfer are liens for real estate taxes. Those stay put. The treasurer gets paid first, always. But after that, the proceeds will satisfy the liens in order of priority. So they're not out of luck. It allows the property to transfer free and clear of encumbrances, and then all the liens are transferred to the sale proceeds. That's right in the statute. Well, I thank you for your attention. Sorry, did someone else have a question?
Get paid off, or do they still remain on the buyer?
Well, the security will be discharged. The liability would still exist. It would just be an unsecured liability, unless there's a personal guarantee or whatever, if there's other security. It's just the security that's transferred over to the proceeds. Thank you, everybody.